Good afternoon, everyone. Welcome to OFN's public policy webinar. We'll just give it another minute or two to let everyone log on. Thanks for joining. All right, good afternoon, everyone. We're going to go ahead and get started. So welcome to OFN's, I believe this is our first public policy webinar of 2024. So we're really excited to have you all joining us today. I'm just going to quickly go through the agenda. So if you go to the next slide, please. So today we're going to do things a little bit different than we usually do. We're going to start off with a discussion of something that I know is top of mind for many of you, which is the legal environment facing CDFIs. And we're going to have a few really exciting and knowledgeable guest speakers join us. And then after that, you'll hear from the public policy team about our 2024 policy priorities, what's going on with the Biden-Harris administration, what's going on with the 118th Congress, and then, as usual, some tips and tools that will help you get involved. Just a couple of quick housekeeping notes. Please feel free to put your questions in the Q&A. We will try to answer as many of them as we can, including we'll try to leave some time at the end to answer some of your questions about the legal environment discussion. Feel free to connect with your colleagues in the chat and have discussions there as well. And of course, we will be recording this and we will make the slides available for you after the webinar. Next slide, please. So with that, I want to invite our guest speakers to join me on screen. We are joined by Denise Noel, who is the EVP and General Counsel at LIIF, and Katy Youker, who is the Director of the Economic Justice Project at the Lawyers Committee for Civil Rights Under Law. So Katy and Denise, thank you so much for joining us this afternoon for this really important discussion. So I'm really pleased to have you here today because, you know, this is an issue that really is top of mind for a lot of our CDFIs, but also our partners, our funders and investors, and really anyone who's been working in the DEI space or on issues that involve racial equity. So there's been a lot of industry conversation and concern about the legal environment that is facing CDFIs and other kind of mission-focused groups over the past several years. We know that race-conscious programs are facing legal challenges that could have significant implications for our industry, both the current work we're doing to direct resources to communities of color, but also these lawsuits can impact kind of our broader efforts to advance racial, economic, environmental justice. So that pushback to DEI and race-conscious programming has reached our industry, and it's an ongoing concern in our environment. So we're going to unpack some of that today with the help of our wonderful panelists. So Katy, can you just kick us off with some broad perspective on the emerging trends in this kind of anti-DEI, reverse discrimination, some of these lawsuits that have been popping up throughout the country?
Sure. Thanks, Stefina. And thank you so much to the Opportunity Finance Network for the opportunity to join you guys today. Always just very inspired by the work that your sector is doing to advance racial equity. So the Lawyers Committee for Civil Rights Under Law was established in 1963 at the request of President Kennedy to use the private bar and sort of the power of the bar to advance the goals of the civil rights movement. And since that time, we've been advocating inside and outside the courts to advance racial progress. And our organization represented a multicultural group of student interveners in the Students for Fair Admissions Supreme Court cases that came down about a year ago that basically ruled or severely undermined and sort of pared back the circumstances in which race could be considered as a factor in college admissions cases. So our team was representing these student interveners from the trial court level all the way to the Supreme Court and helped argue the cases there and continue to represent students in other cases around the country. So the fight continues, but even before the SFFA ruling came down, we started to prepare for these attacks in other sectors, which began before the ruling. And so I'll give you sort of a quick overview of these attacks. And this is can be kind of difficult to hear because these attacks are having a real chilling effect, as you said. And we're going to get through kind of this bad stuff first, the bad news first, and then hopefully we're going to end our session talking about what people can do to continue their work and why we see that this work is so necessary to continue and how to go about doing that. So first of all, most of these attacks alleging reverse discrimination that are seeking to undo racial equity programs or DEI have been brought by just a handful of ideological activist organizations. These include the American Alliance for Equal Rights, which was formed by Ed Bloom, America First Legal, which is led by Stephen Miller, formerly of the Trump administration, Pacific Legal Foundation, and a few others. Now, they really don't represent the majority of American sentiment around DEI and racial equity, and that's been shown through numerous surveys and studies. And these lawsuits and attacks are just one part of really a politically motivated campaign that is seeking to erase history and silence experiences and deny opportunity and power, particularly to Black communities, but other communities of color. Now, this campaign is effective because it relies on fear, and they're trying to divide us. So bringing cases, for example, attacking affirmative action in contracting on behalf of white women, disabled veterans, and Asian Americans. And they're also describing a zero-sum reality where giving to one group necessarily means taking from another. And this is a false threat, right? Our democracy and economy has plenty of room for all of us to prosper. The real threat comes from doing the work of these groups for them, right? And that's what we're going to talk about today. Now, we understand that every organization has its own risk tolerance, and that is absolutely within the best judgment of each organization to decide what they can do within this current climate to continue to advance their mission. But we're here to really hopefully empower organizations to continue this very critical work within the confines of the law and to have accurate information about what is lawful and what is maybe more likely to receive increased scrutiny in the face of this very well-coordinated, well-funded current attack. So these groups are having mixed results in the courts. And again, the chilling effect is the same, but they're, in addition to the lawsuits, they're also sending threatening letters. They have been advancing model legislation across the states that are seeking to undermine DEI and also ESG, and a number of other measures that they've been taking. The lawsuits have been brought across a broad range of sectors. Primarily, these are found in government contracting and procurement programs at the federal, state, and local level. Also, with respect to private grant making. So this is targeting like nonprofits and corporate charitable giving. Another big category is in private fellowships by employers. They've also been challenging DEI policies by private employers and public policies affecting DEI at the state and local level. Now, they haven't come at a CDFI fund for its lending practices yet. There is one challenge that we've seen pop up in San Diego that I'm happy to talk about later that has to do with housing assistance for first-time home buyers. But we have seen one CDFI at least that was sued as sort of an agent for a grant program that was run by Progressive Insurance. And that was that is an ongoing case in Ohio that is American Alliance for Equal Rights versus Progressive Insurance. We led a civil rights brief in that case. We also led a civil rights brief in the Fearless Fund case, which involves private grant making. So again, while these attacks began before the ruling in the UNC Harvard case, many of these lawsuits filed after the ruling are citing those cases as support, even though that case was limited to Title VI and Equal Protection Clause claims. And for some CDFIs that are set up as nonprofits, it's, I think, questionable whether they would be subject to the same type of scrutiny that was applied in the college admissions case. The other big difference is that the compelling government interest in college admissions case was diversity, so increasing diversity of student body. And it's always been something different in terms of lending programs. It's more about remedying past and present discrimination, which is just a whole different set of considerations than were at play in the Harvard and UNC cases. So that's sort of an overview of where we are. I'm going to turn it over to you again to kind of get down into the specifics of this industry.
Thank you so much for that overview, Katie. And Denise, I want to bring you in here because we, your expertise is both as the general counsel of a CDFI, but also you worked at the CDFI fund as their general counsel. And so, I think Katie started to touch on some of what this potentially might mean for our industry, but can you just, hone in a little bit more on like, what does this mean for CDFIs? What do CDFIs need to know about this current legal environment?
This conversation, I think, sucks all the air out of the room, but I think it's so important for people to remember that this doesn't mean the work we're doing is illegal, that this work is still legal. It remains legal. We should be careful. We should be prepared. We should be doing it, within the confines of the legal structure. But just because someone is suing, shouldn't negate and shouldn't cause us to run away from this work that we know is important. And we need to consider sort of both the risks of doing this work and the risks of not doing this work, which we know is also tremendous. We should monitor, be informed so that we can inform our boards. We should know what's happening with this litigation and what it means and the implications when, certain rulings come down and certain things happen for CDFIs. But we should continue to move forward with the work that we're doing, just in a smart, I think, and educated way, is definitely how we're approaching it at LIIF.
Great, thank you for that. And we'll get into a little bit more as we go through the conversation. But Katie, I want to turn back to you for something that you kind of noted in your initial remarks, which is the potential for a chilling effect on the work that we're doing. And in particular, I want to talk about what you might be seeing and hearing from funders reacting to this legal challenges. So any comments you have on, particularly on the federal side, are there federal agencies that might be changing their practices? We know that the SBA and the Minority Business Development Agency, though they have both faced challenges in some of their programs. So what are we seeing there? And then same question, but on the private side as well.
Sure. With respect to the federal agencies, the way that they're set up is by regulation. And so they can't just change the way they do things, right? I mean, and I guess to some degree they can through rulemaking, but the only changes that we've seen are the SBA and MBDA because of the result of these injunctions that were put in place. The SBA, both of those cases involved the use of a rebuttable presumption that is used in many contracting programs that are set up to the benefit of minority-owned and women-owned businesses. With respect to the minority business enterprise programs, these programs are set up right to serve socially and economically disadvantaged businesses. And anyone can be a socially economically disadvantaged business. It's not limited to any particular people of any particular race. But there was a presumption that that many agencies use and still use, and the SBA and MBDA used, that says if you are a member of a certain racial or ethnic group, that you sort of are automatically presumed to be a member of a socially and economically disadvantaged group, and therefore qualify, if you meet the other requirements for the program, that you meet that, that particular requirement. That presumption is what 2 district courts, one in Texas and one in Tennessee, have said was unconstitutional and violated the Equal Protection Clause. And they applied a permanent injunction as to the use of the rebuttable presumption with respect to the SBA 8A program and the MBDA, the Minority Business Development Agency. They have resource centers, as many of you all know. And so what the SBA has done is gone to a narrative process. So now everyone has to submit a narrative describing the discrimination that their businesses faced in the contracting process or in setting up and operating a business. The MBDA has moved to a certification process where an applicant will certify that they meet the requirements of being socially and economically disadvantaged. These cases are still being litigated. It's important to note that, but these are the at least temporary changes that those agencies have made. But we're not seeing changes in other agencies. And it's important to note that there are a number of these lawsuits against this, challenging the rebuttable presumption and a number of other cases and challenging other sort of government contracting programs. Some of those they're not successful lawsuits. So I think what we're seeing is really a setup for a circuit court kind of split, and that will most likely be considered by the Supreme Court in a number of years, I would guess. But there are a number of cases that have been both successful and not successful, challenging these government contracting programs across the states. So we really have, that's where the change has been limited to that area. In the private sector, though, at least with respect to philanthropy, we have seen a mix of funders who are kind of overreacting, I would say, and deciding that they're not going to fund racial equity programs anymore, or at least pause it. They've been telling grantees that they need to make changes to their programs to avoid getting targeted. And a lot of that is just not really based on any, I feel very in-depth analysis. It's just sort of reactionary and overly cautious. We also see some foundations that are saying, hey, we recognize that we do not want to be part of the problem and that this is the moment to really lean in. This is when our support is more necessary than ever. And so we're really seeing kind of a mix. But we are, again, here to support. We've been doing a lot of public education with philanthropy, with nonprofits, and other sectors to provide our services and help guide these industries as they navigate this new landscape.
Excellent. Thank you for that perspective. And Denise, what are you seeing from LIIF side of the house, from your relationships with funders and how they're looking at this moment?
Yeah, certainly a lot more questions, right? And I think what we've done is work to be prepared when we're going forward for funding for our special purpose credit programs or any sort of race conscious program, because it's been increased scrutiny. They want to see that we've been prepared, that we're thinking through, that we've looked at the legality of our programs, and that we're sort of taking an offensive stand even as we continue to do the work. So we're definitely getting more questions. We have not seen yet anyone who's pulled back from funding those programs for us, which is really, we're definitely grateful for that. But I think that's probably due to a large part that we have been able to sort of make people comfortable that, hey, and educate people, right? Hey, this is legal. Hey, this is how we think about it. Here's who we've talked to. Here's what could happen, and here's our plan, for continuing to do this work, and then reemphasizing how important this work is, that we're doing. So that's sort of how LIIF has addressed it, and at the same time, I have heard, as I've talked to folks around the industry about this issue, that, other folks are pulling back, very clearly applications that they've last year may have had questions that, wanted a robust discussion of how, racial equity was going to be addressed in, once, utilizing the funding. Then now there's no mention to those types of things in the applications anymore and stuff like that. So, it definitely, there's a chilling effect happening. And, for my part and for with the funders we work with, I just find that us having been proactive and prepared has put them more at ease to continue to fund the work that we do.
Absolutely. And, just to sort of dive a little bit deeper, because I know a big part of the reason why, folks are tuning into this part of the webinar is because they want to know, what should we be doing? Like, how do I get my organization prepared and ready? So from your perspective, Denise, how would you approach these recent challenges and lawsuits? Like, what actions should CDFIs be taking or thinking about to kind of safeguard their mission and their lending activities?
Yeah, so I mean, the first thing, like I think that's the most important, and we'll continue and we'll try to pick Katy's brain on this too, but is monitoring, right? Like knowing what's going on in the industry, because you hear and then most negative things get the headlines, right? And so I think there was some headline about, some number of attorneys generals wrote letters to people about their DEI initiatives, but more attorneys general wrote letters in support of DEI initiatives, but that doesn't get the airtime, right? The fact that there were all of these, I think it was like 22 attorneys generals in support of DEI, and there was like maybe 12 who were against it, and so that doesn't get the airtime, right? Because negative news always sort of steals the thunder. So just being aware and monitoring this, because your board's going to ask, your staff is going to ask, right? And people are going to want to know, and so I think like that's the sort of the first step. And then connecting with experts. So like talking to folks like Katy, attending programs like this, so that, getting, advice and counsel on the programs that you're running, so that, knowing what this is a big one, knowing what programs you're actually running. Because I thought I knew all of the race conscious programs we were running until I actually started talking with staff and then discovered we were actually doing a couple of other things here. So I think it's really important to ensure that everything that's going on within the organization, and that it's operating, sort of within the confines of what is currently legal. Being close to the board, being close to staff. I mean, I know that at LIIF, it's very important. I mean, we've sort of put a stake in the ground on racial equity in terms of our work, and it's very important to our staff, and making sure that we keep them close and that they know what they're doing, and that it's still important, and that we aren't pulling back, but that we're just making a point to be prepared. It's definitely making sure, like we've done a crisis management plan, right? So it's just thinking about, like, if LIIF got sued, what would we do? What are the first things that we should do? Who should we contact? Who can assist us? What would happen? Just being prepared, because this kind of activity is the sort of thing that I was saying, like, has helped funders and our board get comfortable with us just continuing to do the work, because they're like, all right, so we can go forth, but we're prepared, right? And we're ready to if anything were to happen, we're ready to do that. And I think definitely doing program assessments. So the special purpose credit programs, so that's the lending program, ECOA carve out. Nonprofits aren't required to have like a written needs assessment for their special purpose credit programs, but we're doing one anyway. We think that it's important that we document it. We think that it will give us, a leg up if something were to happen, if we were to get sued for one of our programs. And so we're doing the documentation that's required of for-profits anyway, regardless. And then, I think also like talking to investors and just keeping them close and making sure they know what you're doing, and still feeling comfortable and feeling that you can do this work and then handle if anything sort of negative comes out of it.
Absolutely. Excellent advice. And Katy, I know that your organization also is thinking about this a lot and, doing a lot. So what tools and resources exist for CDFIs that are doing exactly what Denise mentioned, which is trying to figure out how to navigate these challenges?
Yeah, it's good to talk to, a lawyer. I think it's, it's good to do a risk assessment. I mean, it's not a bad idea, but just realize that a lot of counsel may not have experience with like a reverse discrimination consideration. Like they've never really thought through like how these programs could potentially be, the basis of a claim to kind of bring down the whole the whole CDFI sector. So we realizing that we did set up a pro bono initiative that's called Protecting and Advancing DEI, and we provide tailored advice to entities that don't have outside counsel or legal counsel, and that are seeking, the sort of approach of a mission-aligned organization, a civil rights organization, to take a good look at their programs and then offer sort of a risk assessment and strategies for how they can continue their work and different options. So, that's available, and it's something that is in the chat now. So feel free to apply there. We, want to second what Denise just said, that I think special purpose credit programs is a good way to offer some level of insulation for a lender, because it is this carve out, and I think it's good to go ahead and set that up. And I also agree with Denise that taking additional measures, like, so that I guess there are two sets of guidelines for for complying with the special purpose credit program, one for profits and one for nonprofits, as Denise was talking about. And I think if you follow the one for profit banks and lenders is much more onerous, but if you followed those, it's basically, going to provide a good roadmap of evidence for you, I would say, in terms of defending a program. So even though it's not required, and I think there are good arguments for why like strict scrutiny would never be applied to an organization that had set up a program under this regulation, that nonetheless is just an added layer of kind of defense. I mean, we get this question a lot too about like, well, we collect demographic data from borrowers, and can we even do that? Can we report on it and that kind of thing? And absolutely, that is still very much lawful. It's done in many sectors and across the government. And so, yeah, you can just see the chilling effect is really kind of getting out of hand. Yeah, those are some ideas. I wanted to ask too, if there are any members that are like purely nonprofit that don't get any federal money, or for the most part are members getting some kind of federal money.
I think most CDFIs are probably getting some kind of federal or state or local dollars. Some kind of public sector dollars are usually part of the capital mix.
Yeah, I was trying to think if there were any nonprofit lenders that maybe weren't certified CDFIs that were engaged in like lending activities, but not through the CDFI fund, right? Because the analysis looks very different if you're a nonprofit that's getting purely private donations versus someone who's subject to Title VI because they're getting federal financial assistance from the federal government. But nonetheless, this carve out in ACOA is very helpful, and there are lots of regulations that, not lots, but there are HUD regulations, other regulations that have said that using a racial and ethnic category for defining your target population is permissible. So I think there's good defenses available to your industry. And again, I would seek legal advice before making a bunch of changes, that and really looking to, if you are going to make changes, to make sure that there's evidence to back the effectiveness of those changes before you do so. So I hope that was somewhat helpful.
Great advice from both of you. And I know we're getting close to the end of our time, but I do want to address some of the questions that have come in through the chat before we let you go. And I think I can collapse a couple of them because they're related. There are quite a few asking about kind of the future of the CDFI fund and whether the agency itself could be at risk, or if any of the kind of other targeted populations that allow you to direct resources to particular communities, if any of that work could be at risk. So maybe Denise, we'll start with you since you are an alum of the CDFI fund, and then Katie, feel free to chime in with any advice as well.
Yeah, I mean, I think this was certainly a concern, at the CDFI fund when I was there. It is possible that someone could challenge sort of the validity and then the ultimate funding of CDFIs who are certified at serving other targeted populations. So it is certainly possible. We have not, I haven't heard of anyone directly doing that. They weren't directly doing it while we were there, but it was definitely a consideration, and something that we were thinking about and concerned about. The CDFI fund, just recently, the equitable recovery program has dropped kind of this time last year, which is directing funds to, utilizing census tracts. So, I mean, that was obviously a deliberate action to sort of take away sort of that race conscious lens on that program. So that's, using census tracts, majority minority census tracts primarily, as opposed to, directing it towards individuals based on race. So it's certainly something I think that every agency who's operating like programs are keeping an eye on, at this point. So.
Anything to add, Katie?
Yeah, I mean, I agree that like in sort of a bad worst case scenario, I think you could see federal enforcement agencies bringing the types of challenges that these sort of ideological groups are bringing now. You could see the rollback of regulations and helpful guidance regarding topics like special purpose credit programs. You could see regulators going after regulated entities for their DEI programs during the supervision process, and Congress cutting or eliminating fundings for good programs like the CDFI fund. In a non sort of worst case scenario, I think things would look much like they do right now with if the Democrats, let's say, somehow keep the Senate and won the House, you could have more funding available for good programs or even authorization for good new programs. Such as something for like first generation home buyer assistance programs and the like. So I think there are very different scenarios depending on what happens here this year.
Absolutely. And we love to have a little bit of positivity and kind of a pretty dark conversation topic. And so I think the last question I'll pose to both of you is, kind of given that we are in such a tricky situation with the courts, is there some sort of legislative or regulatory strategy that the industry should be thinking about that could actually help, whether it's building out the congressional record or kind of building that body of evidence that we need to kind of demonstrate why we need these types of programs. So any thoughts that you all have on that would be, I think, welcome to this group as well.
Yeah, I really defer to Denise and your policy people right on this, because you understand the agencies at issue here much better than I do. But I mean, that is something that we're civil rights groups are advocating, at least with respect to government contracting programs right now, is that's exactly why they've been knocked down by these two courts. Their presumption is because the courts, now we don't agree with their interpretation of strict scrutiny analysis in those cases at all, but they've been really digging in the disparity studies and say this wasn't sufficient. This isn't sufficient evidence, not specific enough. It's not, you didn't, show that you had considered alternatives. And so I think that it would be good for the industry to or Treasury to take a look at the underlying congressional record supporting this program, seeing if there are other ways to defend it. And one thing I was thinking, I don't know if it's a good idea, but maybe would it be helpful to have guidance from Treasury right now? And is this the right time to ask for it? That I would leave to you all, but we're getting a lot of requests for guidance and assistance. And I think where's the authority in this to help navigate these waters? But I turn it over to Denise.
Yeah. I mean, I think the first thing to me that comes to mind is like industry coordination, like broad industry coordination in terms of data. Only because I think when you're looking at doing a needs assessment for like a special purpose credit program, I think it's very easy to get it for like home mortgages. It's not as easy to have data that supports other programs. And so I think that's just really hard for an individual CDFI to take on its own, right? To try to figure that out. So I would love to see like broad coordination to, that would, help us demonstrate the necessity of the programs that we're running, right? And then I think in terms of, working with federal agencies, of course, any sort of clarification of like Title VI implications with respect to, ACOA and stuff like that, of course, that would be like super welcome. I don't know that we're going to get that. But, but that sort of support, I think, would be really great. And then within Treasury, I mean, always, I think any sort of clarification we could get around, I'm sure folks are going to have a lot of questions and concerns, even, around the equitable recovery program and the things that they committed to do within those applications. Because I'm sure people spoke to serving targeted populations, even as they were looking at majority minority census tracts. And so I'm sure people will have concerns and challenges, and, as they're implementing that funding that they receive from Treasury. So I think guidance around that would be great. But yeah, having been in the federal government, I know sometimes it is tough to, to come out in certain climates. It can sometimes do more harm than good. So.
Absolutely. Well, I just want to thank both of you for taking the time out to, really speak to this critical topic for the CDFI industry, and, to let everybody in the audience know that this is the first, I think, of many discussions and, opportunities for us to come together, as Denise said, to really have that industry coordination. And so OFN is going to continue to kind of build some momentum to make sure that we're making sure that the industry is prepared to address whatever comes our way in the next kind of legal battle that we know we're likely to face. So thank you so much for your time and for joining us this afternoon. We really appreciate your expertise and your help. We will be calling on you again. I am positive of that. So with that, I will let our guest speakers go, and we will continue on with the rest of our presentation. So Mary Scott Bayless and Sophia Gilkison, thank you so much, Katie and Denise. I'm going to invite Mary Scott to join us on screen, our Senior Vice President of Public Policy, to take away the presentation. Thanks so much.
Thank you, Davina. And thank you to all of you and to our panelists for joining us today for that discussion. We're going to switch gears now and move to a broader policy update, moving beyond the legal system. Like Davina mentioned at the beginning, talking about our agenda, we are going to touch on both the Biden-Harris administration and the 118th Congress, and update on some issues that CDFIs are currently facing and that the policy team is working on. I want to start off with this summary slide of our 2024 policy priorities. We will have a link later in the document to our full policy priorities document, which includes much more detail, bill numbers, and things like that. And it's also already up on the public policy webpage right now. But we are concentrating on these buckets that are outlined here. So increasing maximizing federal grant funding, and increasing access to federal lending programs, mobilizing our network and partners to influence the public policy environment. So really embracing grassroots work in policy as well. Expanding the role of CDFIs in climate and resilience finance, and we will touch on GGRF a little later in the presentation, where I'm sure there's a lot of interest. Boosting private investment in communities and CDFIs. Typically when working with the federal government, the way we're looking to support that is through tax incentives and tax programs, advancing policies that promote consumer protection and fair lending. And then our last one on promote is promoting equitable access to capital and safeguarding as much as we can against the legal issues that our panel just outlined there. So let's move and let's start with an overview of the calendar. So next slide. 2024, as I'm sure you all know, is an election year. So it becomes a tough calendar to try and get things done here in DC. This summer, starting in the middle of July, we move into convention season. Most of August and most of October, members of Congress will be back in their districts campaigning. And this calendar doesn't just impact Congress. The administration obviously will have priorities that are driven by the election calendar as well. So let's get into the administration on the next slide, please. Thank you. So for the Biden-Harris administration, there's going to be significant focus this year, and already has been, on codification and implementation of their priorities and programs. So this is going to be working to preserve as much of their policies into federal regulation. So through rulemaking, codifying as much as they can, getting it, into into the agencies as deeply as possible. That is somewhat in preparation. If there is an administration change, that it would help preserve some of that work. But they're also looking to implement as many programs as possible to kind of get those projects out and moving so that voters can see the work that they did. So that's, like I already mentioned, GGRF. There were a lot of programs in the Inflation Reduction Act that passed in 2022 that are now, we're starting to see money flow and projects begin to be funded and move forward. So the administration is going to be very focused on those programs, promoting their successes through media, trying to recognize the work that they've been doing. Like we've already mentioned, there have been significant court rulings. We're going to touch on a couple, at least two other ones later in this presentation. Court rulings will continue to impact the regulatory environment and what the administration is able to do over the next couple of months. I'm now going to turn it over to Sophia Gilkison, the Senior Associate on our Public Policy team, to get into the details of a couple of issues that we are tracking on the administration side. Sophia?
Yes, hi, thank you. So we'll go to the next slide. And yeah, on the theme of implementation, the CDFI fund released their new certification application, as we all know, in December of last year. Currently, all certified CDFIs will be required to reapply for certification using this revised version of the application by December 20th of 2024. Until this date, anyone that is currently certified will retain their status and maintain eligibility for all CDFI fund programs that require CDFI certification. Next slide. OFN is hoping to support our membership as they transition to this new application. So we're hosting virtual office hours for members to ask questions about certification. We plan to aggregate any questions we can't answer and send them to the CDFI fund as well. So the first one will be in about a month on May 15th at 2 p.m. Eastern. We have a link here, but we'll also be sharing this ahead of each of these dates. If you have any immediate questions you'd like to share with us, you can email this new email address we've created, certification@ofn.org with questions. Next slide. Also in implementation news for the year is the Community Reinvestment Act. As we know, this final rule came out in October of last year. This came after decades of reform efforts during which OFN advocated tirelessly. We were really pleased to see that the rule provides automatic favorable consideration for bank loans, investments, and services with certified CDFIs. The rule also provides equal weight to a bank's retail lending and community development activities. Kind of in more recent news, along with the legal challenges, in February, the American Bankers Association, Texas Bankers Association, and several chambers of commerce filed a lawsuit to halt the implementation of the rule. This lawsuit asserts that regulators went beyond their statutory authority in the new rule, particularly in requiring the new retail lending-based assessment areas. It also challenges new reporting and data collection requirements. Currently, where it sits is there is an injunction just in place for the plaintiffs. So next slide. Oh, and I should mention that we'll continue to keep you all updated as new news comes about on the theme of monitoring. Section 1071. So again, an implementation effort from the administration. The final rule came out for Section 1071 of the Dodd-Frank Act last March. As many of you know, this is a small business lending data collection rule that we've been very supportive of, hoping to clarify the murky landscape of the small business lending sector. The way the rule was written, the largest lenders, so those making more than 2,500 loans in a year, were set to start reporting in January of this year. However, there's currently a nationwide injunction on the rule, and this is while we wait for the Supreme Court's ruling on a case that will decide whether the CFPB's funding structure is constitutional. Once we have the Supreme Court ruling, the lower courts will be able to decide on the lawsuit that was filed against Section 1071. So that's where we're at. Again, we'll be monitoring this issue and keeping you all informed. With that, I will pass it back to Mary Scott.
Thank you, Sophia. And as promised, another key implementation piece that we are tracking is the Greenhouse Gas Reduction Fund. As many of you, I'm sure, are aware, the awards for 2 of the 3 programs under the Greenhouse Gas Reduction Fund, the National Clean Investment Fund and the Clean Communities Investment Accelerator, were announced earlier this month. OFN was honored to receive $2.29 billion, so just under $2.3 billion through CCIA, and to see so many of our partners and members and allies also receive funding under both programs. I know everyone is very eager to figure out how money will flow and how this can get out into communities. EPA is currently working to finalize agreements with all of the awardees. It's a brand new program, so they're standing everything up from scratch. So it's going to take a little bit longer in order to get everything up and running. But they are hopeful to have those agreements finalized with the awardees by July 1st. So then at that point, the awardees will be able to start moving forward with their plans to deploy the funding. So we have a website up, ofn.org/climate. It's where you can stay up to date on all of OFN's plans. There's some contact information there if you have any specific questions, frequently asked questions we're posting there. And obviously, as we are able to finalize our agreements with EPA, we'll have much more to share about our plans moving forward. This has the potential to be a really game-changing investment into the industry and into moving toward a more equitable and environmentally clean economy. So if we can move to the next slide to talk about GGRF a little bit more. So as you may have seen in some of the coverage of it, this program has attracted a lot of attention, not just among CDFIs and community lenders, but among Congress as well. Republicans in the House on the Energy and Commerce Committee, which is the one that has jurisdiction over the Environmental Protection Agency, held a hearing earlier this year. So back in January, they held an oversight hearing on the program. The program had not made any awards. No single dollar had moved yet, but they were already having EPA come in and testify about the program. There were a lot of accusations of it being a slush fund and a giveaway to Democratic allies, that all the money was going to flow to Chinese companies that are manufacturing solar panels, et cetera. So this is going to continue to get a lot of attention. I did include, some of the social media discussion from members of the committee that we're seeing so far. But it's not just, House Republicans that are very interested and invested in this program and are tracking it very closely. We have continued to hear a lot of questions from Democratic champions. This program was over 10 years in the making for members of Congress. There's a lot of investment in it from an emotional standpoint, I think, for several members of Congress. And they're also tracking the accountability of the program very closely. They're very focused on the environmental justice goals of the program, making sure it meets the Justice 40 commitment for 40% of the funds at minimum to flow to low-income and disadvantaged communities, and making sure that it does reach the environmental goals and the greenhouse gas reduction goals that were outlined. So although this is in the hands of EPA and is definitely a federal agency program, Congress passed this legislation in August of 2022. It's been over a year and a half. There's going to be a lot of continued congressional interest in the program. And speaking of Congress, we want to go to the next slide. We can get into some of the discussion. So next one. So in Congress, we are dealing with a unique situation. I think this Congress has been particularly unique. As you know, we've already been through multiple House speakers. I was seeing just this morning, the House is passing several, or looking to pass several foreign aid and foreign affairs bills this week. And so there's increased threats to Speaker Johnson with people who are opposing the path forward there. I'm not sure that we're actually going to see another change in speaker, but there are threats being made and petitions being filed among members to try and move to another speaker. But we have bitter partisanship between the House and Senate and between the House and the administration, party infighting, particularly in the House. As you can see from the illustration here, this was during one of the speaker elections. It sometimes devolves into actual fighting, not just verbal disagreements. And as we talked about earlier with the calendar, they have limited time in session. In the small calendar you can see on the screen, anywhere where there's no color at all means that the House and Senate are both back home in their districts, not in DC. Additionally, there's a lot of effort being put in the House in particular to stall the Biden administration agenda rather than actually moving legislation forward. Next slide, please. So what does this mean for some CDFI priorities? I'm going to start out with talking about FY 2025 appropriations, so funding for the CDFI fund. In FY 24, the CDFI fund received $324 million. There were a lot of threats for cuts to the CDFI fund. So although we were a bit disappointed in the final number, at least we were able to preserve the fund from being cut, as the House had originally proposed a more than $40 million cut to the CDFI fund. The president's budget requests a slight increase to the CDFI fund of $1 million, but does include another priority of OFNs, which is a $10 million credit subsidy for the bond guarantee program. And this would allow the bond guarantee program to become a little bit easier to use for smaller CDFIs. Now, it wouldn't improve everything with the bond guarantee program. There's actually some legislation that we'll mention later on that would address some of the other issues. But the budget also touches on other priorities, like making the new markets tax credit permanent and a few other areas. But the budget's an outline of the administration's priorities. Congress has the power of the purse, and they will ultimately decide spending levels. Next slide, please. Speaking of who's deciding the next spending levels and the continued turmoil in the House, within the past about week and a half, we have had some new leadership changes on the Appropriations Committee in the House. Representative Kay Granger, who was the chair of the Appropriations Committee from Texas, had already announced that she was not running for re-election. And shortly after Congress was finally able to pass the fiscal year 2024 bill, last month, she announced that she was stepping down as appropriations chair as soon as a new chair could be selected. And then the Republican caucus got together and selected Representative Tom Cole from Oklahoma to become chair of the House Appropriations Committee. And then this set off a domino effect of subcommittee chairs moving around. Tom Cole was also the chair of the Rules Committee prior to assuming this position. So there was some restructuring there. And that resulted in a new chairman for the Financial Services and General Government Subcommittee, which is the one that directly oversees funding for Treasury and the CDFI fund. So our new chairman, replacing Representative Womack, is Representative David Joyce from Ohio. And both of these announcements were made within about, I believe it was last Tuesday when they were put into place. So even in not an election year, we've continued to see a lot of movement around in the House. Next slide, please. For FY25, we are seeing very tight spending environment. So funding increases are going to be challenging. However, we know that there's significant demand for the CDFI fund grants and other programs. So we are pushing forward, asking for a larger increase than what's in the president's budget. We're requesting $350 million for fiscal year 2025. We're working with our bipartisan champions to secure this funding. We believe that we will have bipartisan support in both the House and the Senate for increased funding. It's just a matter of getting it over the finish line and dealing with everything else that's going on in Congress at the same time. We are out there trying to push as hard as we can to bring attention to the needs of CDFIs and the great work that all of you are doing in communities. Sophia is going to touch on a little later on our Take Action page, some ways that you can get involved to help encourage your members of Congress to support an increase for CDFI spending. Next slide, please. So one other piece of legislation that I wanted to touch on is some of you may have heard about the tax bill that has been floating around for the past couple of months. So the Tax Relief for American Families and Workers Act was put together in the House on the Ways and Means Committee between Jason Smith and in the Senate, the Finance Committee chairman by Ron Wyden. So if you are familiar with either of these members of Congress, their politics are very, very different. But they were able to come together to agree on this tax package, which included several business tax provisions that were a priority to Representative Smith, several other priorities of Senator Wyden, including the child tax credit and some other pieces. Although the bill does not include many of our tax priorities, like it doesn't have the new markets tax credit, it doesn't have Senator Warner's specific CDFI tax credit, it doesn't have the Neighborhood Homes Investment Act or the full Affordable Housing Credit Improvement Act. It does include several low-income housing tax credit provisions, which would be very important to our members doing housing work. The House voted on the bill close to 3 months ago now, I believe, and it passed by a wide margin. However, there's continued uncertainty in the Senate, and it does not look like it's moving forward at this time, but we will continue to work either on this tax package, or it's expected that going into 2025, there will be another tax package that's put together that addresses several things that are set to expire in 2025, including the new markets tax credit. So although this bill may not ultimately become law, it may start to lay the groundwork for a larger bill that will be passed in the next year or so. And then on the next slide, I did just want to briefly list out some other bills and programs that we are tracking through the House and the Senate. As I mentioned, we will be sending out the slide deck that has all this information, so don't feel like you have to try and absorb it all right now. And all of these pieces of legislation are in our policy priorities, which are on our website. So we will be sending this out later. And now I am going to hand it back over to Sophia to talk a little bit about how you can get involved and stay informed. And then I can see some questions starting to come in. So please feel free to add some more questions in the chat box, and we'll answer as many as we can at the end. Thank you.
Yeah, thank you, Mary Scott, for all of that valuable context. So like she said, we invite you all to get involved however you can. This slide has a few ideas how you might be able to get involved. Your voice is very important when it comes to demonstrating impact of CDFIs to policymakers here in DC. We have an easy to use form on our take action page. We have a preview on the next slide. I can show that to you guys. So as you can see, right now we have one up for the New Markets tax credit program. There's currently a notice for public comment open. It's super easy to use, shouldn't take you more than 5 minutes. This other one that we have is one that we keep up most of the year. It's specifically for advocating for the CDFI fund appropriations. We already are in the process of fiscal year 25, and it takes less than a minute. All you have to do is click take action, and then it'll direct you to put in your zip code, and it'll pop up your members of Congress. And we've already pre-written a letter. There's room for you to include some information about your CDFI, but we really tried to make it as easy as possible on you all. So we encourage you to use these tools. Next slide. This is some more resources that we have available to you all, including a link out to our public policy priorities, our social media pages. We regularly post blogs whenever there's noteworthy information. We also invite you all to join our new public policy page on the CDFI Connect platform. So if you already have a CDFI Connect account, all you have to do is go to communities and locate public policy. Any members or I think anyone that has a CDFI Connect account is actually welcome to join. We've been posting updates here and requesting feedback from our members. And we're really hoping to see you guys engage on that page. Lastly, you can reach out to us directly. So our emails are here available, and I'll invite Mary Scott to come back and see if we can answer any additional questions.
Yeah, we have just a couple of minutes where we can answer any questions that have come in. I've seen a couple come in, so let me see if we can address those. I know there was a question about, and there was some discussion in the chat that started to answer it, about EPA using a new disbursement process. So this is a brand new program for them. And yes, it's going to be a different disbursement process since all of these funds are going from EPA to essentially intermediaries and then being subgranted out. The process is going to look different. And it's also going to look different between CCIA and NCIF. So we don't have all the details on that right now, but it's going to be a bit of a different process for them, and it's going to be a bit of a different process for the awardees to get used to as well. Then yes, I think there were several questions about getting links in the slide deck. So yes, we will be sharing out the deck and the recording, which will include all the links, and then the discussion specifically on the certification office hours, in addition to being in our PowerPoint as we get closer to that day on May 15th. There'll be more communication coming out about that. You all were the first group to hear about our new certification office hours, so you've heard before anyone else in the network has had access to that information. Then let me just check and see if any other questions have come in specifically on legislation or if there's anything else there. I think that is about it that I've seen. So I just want to thank you all for joining us today. And please, as Sophia said, feel free to reach out to us directly with any questions or concerns. Anytime you are coming to DC, we love to know when you're going to be here. We are happy to help set up meetings for you if you'd like to go visit any agencies or on the Hill. We have resources and talking points, and the OFN office does have some office space that is open to our members to use when they're in town as well. So with that, I will say thank you for joining us, and we will see you all at our next presentation.